and welcome to the Administrator-General and you. I'm Nadine McLeod. You know, when someone dies without leaving a will and leave children under the age of 18 years old, you must report a death to the Administrator-General's department. How do you report a death to the AGD? With me today are Ms. Ingrid Cole, who is the Estate Administration Executive at the Administrator-General's Department, and Mrs. Fernell Daly, who is the Legal Officer at RGD. Thank you very much for coming. Ms. Cole, we'll start with you. What documents are needed to report a death to the AGD?
Okay, thank you for having me, Nadine. The documents required are statutory declaration, which is in the form of a form of particulars. And this is available on our website at agd.gov.jm. We also require proof of the death. And this may be in the form, of course, of the death certificate. If not available, then certainly the burial order, the Form D, if it is that the person died by way of accident, as well as the medical cause of death. That we also require a proof of a minor in the estate by way of the birth certificate of one of the children who are under the age of 18 years. We also would need proof of an asset in the estate. And then all those are submitted to us, and then we would start our investigations.
So you must have a death certificate.
A proof of the death of the deceased, because sometimes the death certificate may not yet be available.
Yes.
So therefore, we would take the burial order in the interim, or if it is that you have the medical cause of death, or the Form D, in the case of an accident, normally a Form D is issued. So if the death certificate is not yet ready, then we will also take that as well. And as I indicated, we need proof that there's a minor in the estate, and that is by way of the birth certificate of that child or children, if there are more than one children under the age of 18 years.
Okay, Ms. Cole. Mrs. Daly, this is where we bring you in about the death certificate. Yes. So someone dies. What's the next step for the family members?
Okay, so that is dependent on where the person died. If the person died in a hospital, there is a 99% possibility that that death will be registered within the shortest possible time. And that is primarily because normally, once the death takes place in a hospital, the doctor who last saw the deceased would have written up a medical certificate for the cause of death, stating that perhaps a post-mortem subsequently by the pathologist. So once we have these, then we can issue the burial order to the relative. And
the burial order is needed in order to do the actual burial.
Exactly. And just to indicate, though, that once the medical certificate for the cause of death or the post-mortem examination report is presented to us, then we use those documentations to register the death. However, if the person did not die in a hospital and the relatives have to consult the police will issue a burial order. This burial order will not have this burial order is only an authorization form for the relatives to bury, but it is not an indication that death is actually registered with us. So what we normally encourage is that those relatives should liaise as best as possible with the police and also with the court's office, because those matters normally go through the court for them to obtain the Form D from the coroner for us to register the death.
What is Form D?
The Form D is a certificate issued by the coroner, having ruled on the matter, either with a jury or without the jury, that no one should be held criminally responsible for the death. So it is really a form called a certificate, and it is issued by the coroner. In this case, it's the parish judge in the outside of the corporate area, or in Kingston as well. We do have coroners in Kingston, and this form is issued after the ruling by the coroner that the RGD now has the authority to register the death.
Sometimes you have people, they have the burial order, and for whatever reason, sometimes they forget to come in and to do the actual application for the death certificate.
Yes.
What happens then? If you remember, say a year later or 2 years later, can they come to the RGD and apply
Yes,
for the death
yes.
certificate?
Well, it depends. So if they got that burial order from the police, there is a possibility that even after a year of the death, those deaths are not yet registered. So what we'll encourage is for those persons to do a search with us first to find out whether any relative in the family had actually presented the required information for the death to be registered. And once they do the search and we find an entry number, they can now use the entry number to apply for the death certificate. But if they have a burial order that was issued by the Registrar-General's Department, then those burial orders will have the entry number on it, indicating that yes, those deaths are registered. And the only thing they will need to do then is to simply apply either online or any of our RGD locations for that death certificate.
Do you have cases where there is no entry number?
Yes.
And what happens in those cases?
So if there's no entry number, those persons will have to do a search, apply to any of our locations to do a search. And hopefully those deaths are in fact registered, because once we find the entry number, the only thing the person will have to do at that point is just to apply for the death certificate. But if we do not find the entry number, then the person will have to apply for a more detailed search, what we call a form search. And the more information that we have on the deceased, sometimes the quicker the results are. So it's always best for the relatives to provide as much information as possible so that it can reduce the time to do the search.
Ms. Cole, those are some of the things that cause delay
Yes, indeed.
at the AGD.
Yes.
Tell us about that, like not having the death certificate,
right,
not registering it properly.
Yes.
Tell us about that.
Because what happens, a lot of persons believe that the burial order, or what we refer to as a pink slip, is actually the death certificate. And it really isn't. And so it prevents us from continuing administration because external institutions require the proof of death. So we would need it, for example, to collect assets in the estate. So if there are funds in the bank will want to see the original death certificate to be able to give us the funds that are in the bank as
So
well.
your hands are basically tied
Yes,
without
yes.
the death certificate.
Yes, it is. It is. So therefore, we encourage persons to take the burial order
Yes.
and go and register the death so that they can be issued death certificates.
Okay. So aside from the death certificate, what other documents do you have to have? You must have those documents before you can proceed with estate administration.
Well, as I indicated before, we would need proof that there are minor beneficiaries in the estate. We also need proof of the assets of the estate. So if it is reported that the gentleman or the lady who died owns a property, we need the proof that the person actually owns a property. And so they are to bring in that information to us. And also, if it is that it was reported that the person has funds in the bank, if they have the bank book, or even if they put the information on the form of particulars that I referred to, then we will write to the bank. So we ask persons to complete the form in detail and provide as much information as possible so that we can use that information to investigate the estates to be able to collect the assets in the estates.
What about you if you don't know if the person has a bank account?
Well, what we do, even if they reported that there are no bank accounts, we still write to the banks. We still write to the banks. That is part of our investigative process.
Ms. Cole, what happens if you find out that the deceased has assets like later, like about 2 years after you started estate administration?
Yes.
Can you still report that?
Oh,
asset?
yes. Oh, yes, indeed. Because the grant is enduring. The grant of administration is enduring. It lasts a lifetime. So even if we had closed that estate 2 years ago and it was reported that there are additional assets, we will reopen the file and we will send that grant of administration to the institution that holds the assets and collect the assets thereafter.
Okay.
Yes.
The other services that the AGD is involved
Oh, yes.
with?
We offer funeral expense advance. And this is in cases where a person has accounts at the bank in his or her name alone, and persons are not able to access it. The person has to be buried. So therefore, we facilitate the bank paying the funds over to the funeral home. But we require the statutory declaration that I spoke of, which is in the form of particulars. We also require the proof of the death of the person. And as I said, they can present us with a burial order or any of those documents that we mentioned before. We also require the invoice from the funeral home. And we charge a fee of $2,000. Then we would write to the bank to confirm that the funds are there. And then our limit is $500,000. And so we will direct the bank to pay the funds straight to the funeral home.
Okay,
Yes.
good service.
Indeed.
You also do motor vehicle transfer
Yes,
in
we
some instances.
also transfer motor vehicles to spouse if it is that there are no other assets in the estate and that vehicle was not being used for commercial purposes. So we'll therefore, so the same thing would apply. They will have to provide us with the proof of the death, the statutory declaration completed, which is the same form of particulars, the marriage certificate to show that the spouses who he or she said they are in terms of the marriage, and they also complete an indemnity form, and there's a fee of $1,500, along with the motor vehicle documents like the title, registration and fitness, and then we would facilitate the transfer to the spouse.
Okay. Earlier you said after the death has been reported that you do investigation. The AGD
Yes.
does investigation. Tell us a bit about investigation and what happens after investigation.
Okay, so once the matter is reported to us, we, as I said, the form of particulars give us information, so to speak. And so we will investigate everything that's there. So you say there are funds at the bank, you say there are shares, you say that there are properties, and whatever the assets are, whatever the person owns, horses, guns, whatever it is. So we confirm that those are indeed within the estates. We'll get a copy of the title from the titles office just to confirm that it is actually there. If the persons have the original title, we encourage them to bring it in to us. For the funds, we also write to the banks to confirm that those assets are there. For the guns, sometimes after the death of the person, it is taken to the police station. We write to the police station to confirm that the gun is there, and we direct them to send it over to FLA. Right? So whatever the assets are, we confirm the assets first and foremost. We then issue a grant of instrument of administration. We are now able to issue our own grant of administration. We no longer are required to go to the court, and that allows us to administer the estate in a faster turnaround time. Within 3 months, we have the grants of administration, and we are able to collect the assets wherever they are. Having confirmed the assets and having issued the grants of administration and having collected the assets, we then ascertain what the liabilities are in the estate, because sometimes there are indeed liabilities, and we would then settle the liabilities, and then thereafter we would transfer to beneficiaries. But please be reminded that if there are minors in the estate, we are mandated by law to keep that estate until that minor reaches the age of 18 years. So if the matter was reported to us when that minor was 15, we have another 3 years to keep that estate. If the minor was reported when the minor was 1 year old, we have another 17 years to keep that estate. But as I said, we take care of the assets, we invest the funds to earn income for the beneficiaries. For the property as well, we pay the insurance for the property. We may rent the property to get income. And so we take care of the assets, and then, as I said, once the child reaches 18, the ones who are under 18, we then transfer the assets to the beneficiaries.
Thank you very much, Ms. Cole. Now, before we go, do you have any parting words for our audience?
Just to indicate that if there are children under, if somebody dies and there are children under 18 years old and there are assets in the estate, please report the matter to us. We have heard of instances where family members go in and take over the estate to the detriment of the children. And so we are imploring persons to report the matter to our department. We are mandated by law to take care of those estates where there are children, especially where there are children under 18.
Thank you.
Okay.
Mrs. Daly?
Yes, what I will encourage the populace to do is to register the death. It's very, very important because we have situations where persons are in their late 60s, 70s, and they're now trying to recall the particulars for the deceased. And sometimes the documentations that they have are either faded or it can't be verified, and that makes the process a lot much difficult for them to register the death. And we really want to use this opportunity to encourage you. Once you get the burial order from the police, that's not the end of the process. It is the responsibility is yours and the rest of the family. So ensure that you follow through with the police and follow through with the courts to ensure that you get the Form D or the certificate from the coroner and take it to the Registrar-General's department to have this death registered. Thank you.
Thank you, Mrs. Daly. Thank you, Ms. Cole. And that brings us to the end of this segment of the Administrator General and you. Thank you for watching.